This video will advise you of your rights and the possible penalties you are facing in this case. If you have any questions about your rights or penalties as stated in this video, you should ask them at the conclusion of the video when you appear before the judge or magistrate.
Good afternoon. My name's Darren Murphy. I'm a magistrate with Hamilton County. We're here today to explain to you your rights. You have a right to a public and speedy trial by jury. If you're charged with a felony, the court will automatically set your case for a jury trial. If you are charged with a misdemeanor, you must make a written request stating that you want a jury trial and file that written request with the court not later than 10 days before your first trial date, or else you waive and give up your right to a jury trial. A judge or magistrate will then decide your case. In a trial or hearing, you have the right to compel witnesses to appear and testify on your behalf. You have a right to see, hear, face, confront, and cross-examine any witnesses and evidence presented against you. You cannot be required to testify against yourself. Anything you choose to say can and may be used against you. At a trial, the state of Indiana has the burden of proving beyond a reasonable doubt that you committed any offense charged before you can be convicted of that offense.
The possible penalties that you are facing are determined by the class of misdemeanor or the level of felony charged against you. For a Class C misdemeanor, the possible penalties are 0 to 60 days in jail and a fine up to $500. For a Class B misdemeanor, the possible penalties are 0 to 180 days in jail and a fine up to $1,000. For a Class A misdemeanor, the possible penalties are 0 to 365 days in jail and a fine up to $5,000. For a Level 6 felony, the possible penalties are 6 months to 2.5 years in prison and a fine up to $10,000. The advisory sentence is 1 year. However, the court may enter judgment and impose a sentence as a Class A misdemeanor, unless you have committed a prior unrelated felony for which judgment was entered as a conviction of a Class A misdemeanor, and the prior felony was committed less than 3 years before the second felony was committed. For a Level 5 felony, the possible penalties are 1 year to 6 years in prison and a fine up to $10,000. The advisory sentence is 3 years in prison. For a Level 4 felony, the possible penalties are 2 to 12 years in prison and a fine up to $10,000. The advisory sentence is 6 years in prison. For a Level 3 felony, the possible penalties are 3 to 16 years in prison and a fine up to $10,000. The advisory sentence is 9 years. For a Level 2 felony, the possible penalties are 10 to 30 years in prison and a fine up to $10,000. The advisory sentence is 17.5 years. For a Level 1 felony other than child molesting, the possible penalties are 20 to 40 years in prison and a fine up to $10,000. The advisory sentence is 30 years. For a Level 1 felony child molesting, 1 by sexual intercourse, deviant sexual conduct, or other sexual conduct with a child less than 12 years old, and you are 21 years or older, or 2, resulting in serious bodily injury or death, the possible penalties are 20 to 50 years in prison and a fine up to $10,000. The advisory sentence is 30 years. For murder, the possible penalties are 45 to 65 years in prison and a fine up to $10,000. The advisory sentence is 55 years.
In addition to these penalties, there are additional penalties which may be imposed by the court depending on your circumstances or the charges filed against you. If you are convicted of a charge involving operating a vehicle or motorboat while intoxicated, or convicted of a crime relating to a motor vehicle, your driving privileges may be suspended for a period not to exceed the maximum sentence allowed for the offense. Additionally, should the court find probable cause that you operated a vehicle while intoxicated and that you failed a chemical test, the court will recommend a suspension of your driving privileges for a period of 180 days. If you indicate today that you intend to file a petition for specialized driving privileges, the court will stay the suspension of your driving privileges for 10 calendar days. Upon the filing of a petition for specialized driving privileges, the court will set a hearing within 30 days. The stay will continue until the court rules on your request for specialized driving privileges. If you do not file a petition for specialized driving privileges within 10 days, or if the court denies your petition at the hearing, the court will lift the stay and will recommend a suspension of your driving privileges for a period of 180 days. Should the court find probable cause that you operated a vehicle or motorboat while intoxicated and that you refused a chemical test, the court will recommend a suspension of your driving privileges for a period of 1 year. But if you have at least one prior conviction for an operated while intoxicated offense, the court will recommend a suspension of your driving privileges for a period of 2 years. You are not entitled to specialized driving privileges if you refused a chemical test. If you are convicted of domestic battery or a crime involving domestic violence, you will lose the right to possess a firearm. Possession of a firearm may constitute a separate crime. Parenting time with minor children may be restricted, and there may be other penalties which are applicable and should be discussed with an attorney. If you are charged as a habitual vehicular substance offender, you should be advised that this is not an additional charge, but it is a sentencing enhancement. If you are convicted of an operating while intoxicated charge filed against you, and you are found to be a habitual vehicular substance offender, you will be sentenced for the operating while intoxicated charge, and the court will add time to your sentence for being a habitual vehicular substance offender. The additional time will be between 1 and 8 years. If you are charged as a habitual offender, you should be advised that this is not an additional charge, but it is a sentencing enhancement. If you are convicted of a felony charge filed against you, and you are found to be a habitual offender, you will be sentenced for the felony charge, and the court will add time to your sentence for being a habitual offender. If you are convicted of a level 6 or level 5 felony, the additional time will be between 2 and 6 years. If you are convicted of a level 4, level 3, level 2, or level 1 felony or murder, the additional time will be between 6 to 20 years. There may be additional rights or penalties that apply to your case due to your specific charges. These will be addressed at your initial hearing. You have a right to be represented by an attorney at all stages of your case. If you cannot afford an attorney now or at any later time, the court will appoint one for you. You will be asked some questions by a judge or be required to complete a statement under oath concerning your finances to see if you qualify as indigent to have an attorney appointed for you at no cost to you. If you intend to hire your own attorney, you should do so within 10 days if you are charged with a misdemeanor or within 20 days if you are charged with a felony. There are deadlines for the filing of certain defense motions and the raising of legal issues that will be waived if those deadlines are missed. You should obtain an attorney promptly so that any motion can be filed within the time limits. The court will enter a preliminary plea of not guilty on your behalf today. This will become a formal plea of not guilty within 10 days from today on a misdemeanor case and 20 days from today on a felony case. If you are here for an initial hearing on a violation of probation or noncompliance with community corrections, you should be advised that your rights differ slightly from those that you have heard in this video. Specifically, you do not have the right to a jury trial. If you wish to contest the allegations contained in the information of violation of probation or the notice of noncompliance with community corrections, you may do so, but your hearing will be in front of a judge rather than to a jury. Also, the state must prove the allegations against you by a preponderance of the evidence. It is not necessary that the state prove those allegations beyond a reasonable doubt. You have all the other rights that were stated in this video. You have a right to counsel. You have the right not to incriminate yourself, the right to see, hear, and cross-examine the witnesses and evidence presented against you, and the right to compel witnesses to testify on your behalf. If you are found to be in violation of your probation or community corrections commitment, the court may terminate your probation or commitment, the court may modify the terms of your probation or commitment, or the court may extend the terms of your probation or commitment. The court may also revoke your probation or community corrections commitment and impose all or a portion of the suspended sentence against you.
In a few minutes, you will have the opportunity to speak with the judge or magistrate, either by video teleconference or personally in the courtroom. The judge or magistrate will review the charges against you. Future court dates will be set, and if you are incarcerated, the court will determine whether to release you to the pretrial release program or to require you to post a bond. If you are released to the pretrial release program, the court will inform you of your level of supervision. You will meet with a representative of the pretrial release program after your initial hearing, and you will be advised of the terms and conditions of your release. If you are not released to the pretrial release program, the court will set a bond. If you are charged with murder, the court will not set a bond. If you are released to the pretrial release program or post a bond, you are subject to the following conditions. 1. You shall appear in court at all times required by the court. 2. You shall not leave the state of Indiana without prior written consent of the court. 3. You shall not commit or be arrested for a criminal offense. 4. You shall keep your attorney and the court advised in writing of any change of address within 24 hours of such change. And 5. You shall comply with any other conditions ordered by the court. The court, or a representative of the pretrial release program, may also advise you of any special conditions of your bond or pretrial release. A violation of any condition may result in a revocation of bond or pretrial release and the issuance of a rearrest warrant.
Please feel free to ask questions. A representative from the Office of the Hamilton County Prosecuting Attorney may be present, and the court reporter will make a record of the balance of your initial hearing.